regular March meeting of the Board of Adjustment for Buncombe County to order. Today is March 12th, 2025. Welcome. We'll move to staff for announcements today. No announcements, okay.
I would like to say that we do have interpretation services here today.
Perfect. Thank you very much. We'll start with a roll call of board members, starting with Joel.
Damian Bacaflor.
Craig Allen.
Andy Ball.
Carol McCrory.
Paul Wilsinski.
And we'll move to staff.
Savannah Glantz.
Kurt Euler.
Griffin Kearns.
Excellent. Thank you all. Approval of meeting minutes. We've got meeting minutes that were emailed out to the board and available online. Those are from the February 12th meeting. We had a special meeting and a regular meeting of the board. Any questions, corrections, or motions on those?
Motion to approve.
There's a motion to approve. Is there a second? Hearing a motion and a second. All those in favor, please raise your hand. That passes. Thank you. Any opposed? That passes. Thank you. Disclosure of ex parte communications from the board or conflicts of interest. We'll move around the table, but first we'll specify what that means. A member of any board exercising quasi-judicial functions pursuant to this chapter of NC General Statutes shall not participate in or vote on any quasi-judicial matter in a manner that would violate any person's constitutional rights to an impartial decision-maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, close familial, business relationship, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. And for this, we'll start again with Joel.
No.
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 Thank you. And moving to our public hearings, before we start those, we will review an opening statement here. This hearing is a quasi-judicial evidentiary hearing, and that means similar to a court hearing, state law sets specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and the standards, not personal preference or opinion. General witness testimony is limited to facts and not opinions. For certain topics, however, this board does need to hear opinion testimony from expert witnesses. These topics include projections about the impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion testimony must be qualified as experts and provide the factual evidence upon which they base their expert opinion. And a point of clarification for those members of the public who are joining us to speak on a project either as a party withstanding or as a witness. Staff has provided resources to help members of the public understand the criteria for the board to find that a party has standing to participate in the case, and clarified the proper time for lay testimony is at the end of the hearing when the board may open up the hearing to consider witness statements. To be clear, if asserting standing in a matter before the board, we must first need to conduct a hearing to establish that you have standing, meaning you believe you are uniquely affected by a project for reasons separate and apart from your neighbors. And if those reasons include elements such as noise, traffic, or property value impacts that you have ready today, a case that you prepared and have brought with you today, or are yourself credentialed or qualified to present expert testimony in those areas. If that doesn't describe your intent today, please consider again whether you would like to assert standing or speak as a witness toward the latter part of the hearing. And with that, we'll start with case ZPH 2024-00035. It's 220 Ledbetter Road, special use permit. This case is continued from February. And Savannah Glantz will present.
Please raise your right hand and state your name.
Savannah Glantz.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Thank you for your patience, board. Technical difficulties.
No worries. We're having technical difficulties. Be just a few minutes, folks. Thanks for your patience. We are waiting on a technical difficulty to resolve. Right. That's a very good observation. I've not seen.
All right, we've got it.
This is fantastic. This is interesting.
Thank you,
Uh,
board, and
thank
also
you for the-
everybody here for your patience.
Patience during the delay here. Thank you, Savannah.
All right, so I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. And I ask that the applicant and staff materials be accepted into the record as evidence.
Hearing no objection on the board, that's so admitted.
Thank you. This is the review of ZPH 2024-00035 to 20 Ledbetter Road. Applicant is Mike Romero of A. Marks Construction. Property is located at 220 Ledbetter Road, and the total acreage is 5.42 acres. The development will be serviced by Public Water and MSD. The property is zoned R2, and the special use permit proposes a 32-lot subdivision with 29 living units within 16 structures. The application proposes deviations with lot size, interior setbacks, and distances between buildings through the SPUD process. And if approved by the board, staff recommends the following conditions of approval. Project must meet all standards of the Land Development and Subdivision Ordinance. Projects must be constructed as depicted in the site plan, and applicant must agree in writing to these conditions prior to the commencement of site work.
Any questions for staff on this? Savannah, real quick, I'm sorry. Did you, is it possible to zoom in on this site plan?
Possibly, I'll have to ask our wonderful communications.
Thanks so much. Do the right-of-ways and driveways line up so that the right-of-ways are sufficiently back from the houses?
So the houses are outside of the right-of-way?
Yeah, that's right.
Yes, the homes are outside of the right-of-way.
Okay, thank you so much. I just want to make sure. It looked close on a couple of them.
Mhm.
Any other questions, thoughts, staff? Thank you. Before we call the applicant up, we'll ask, so we have one application already on file for standing Lifka, is that right?
Yes, that is the sole application for standing that we received, but we did receive on January 9th a request for that to be withdrawn.
Wonderful, okay. Well, then I'll ask then if there are any members of the public here to assert standing in this matter. We will open up later on in this hearing for witness testimony, to speak as, to offer lay testimony, but anyone here to speak as, to assert standing? Going twice, 3 times? Thank you. We'll call the applicant up at this point.
Please raise your right hand and state your name.
Sean McIntosh.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir.
Hi, how are you?
Doing great.
I'm with Cardinal Engineering. I'm the engineer on the project here in conjunction with A-Marks Communities. Here to speak on the 220 Ledbetter Road project. As shown here on the screen, overlaid on an aerial. Project site is southeast of Ledbetter Road and just north of Erica Lane to the south. Our project proposes a special use permit for a planned development level 1. The application proposes 32 lot subdivision, 29 of which are homes, 3 are open space lots. There'll be 29 units with 16 structures. In the dimensional standards that we're requesting are lot size, interior setbacks, and distance from buildings. This request allows for the proposed density to be financially viable and to allow for maximum affordability of units. The approximate construction timeline, assuming we get approvals, will be approximately the summer of this year. They intend to develop market rate townhomes. The site is currently zoned R2. We intend to maintain R2 criteria with adjustments that I will speak to here in a moment. The final site will be landscaped, and we propose a private 22-foot road with 45-foot right-of-way per the subdivision regulations. And there will be an HOA document to maintain the common areas, the underground detention, and the roads. So I'll direct you to the table in the middle of the slide. The top portion is the standard R2 zoning, and the bottom are the PUD zoning criteria that we are proposing with this application. So R2 calls for a minimum lot size of 6,000 square feet, and we are proposing 4,500 square feet. The minimum side yard for R2 is 7 feet. We are proposing 5 feet with a 0 setback where there's shared walls. Most of these units are duplexes, which I'll get into on the next slide. So this is the site layout consistent with what Savannah showed previously. Again, most of the products are duplexes. Units 17, 20, and 29 are standalone units. There are 3 open space lots. One is just west of Lot 1, near the entrance where the monument sign will be located and landscape screening will be provided. The second is between lots 2 and 3, where the underground detention system will be located. And we intend to amenitize the at grade level with a community garden or something of that nature. And then the last open space is just north of lot 29, where the mail kiosk will be located. This slide depicts the grading plan. Proposed grades and storm sewer infrastructure will direct the proposed flows to the underground detention system between lots 2 and 3, where they'll be stored at historical runoff rates and then conveyed to the existing culvert and ditch in Erica Lane. This is an example of the duplex product that A-Marks intends to develop. This is similar to the Cozy Cottage development, which went through a similar process and approval in Buncombe County. So that's the extent of our presentation, and happy to answer any questions you may have.
A question on the underground retention. Is that for the entire site, or is that specific to a portion or an area of the site?
The whole site.
And then I think I heard you say culvert, Erica Lane, something to that effect. Could you repeat or provide clarification of what you were communicating?
Looks like I lost the slide here, but yeah, so there's an existing culvert in Erica Lane and a ditch on the north side of the road, which is adjacent to our site. So we will convey the flows to that ditch, and then it will outlet at that existing culvert, and we'll have to, detain, excuse me, to a level that existing culvert can handle. That's how it's been designed so far.
Does that imply that the underground retention, if it reaches capacity, the overflow will then utilize that culvert?
It outlets to that culvert, but if it were to overflow, if it were to overflow, we would basically just pond in the middle of the development at the intersection. That's the low spot on the site. So it would remain on our site until it is conveyed to the system.
Thank you.
Thanks.
Yeah, you have a 22-foot building height plus or minus on the application here, and then a rendering showing the product, the height of the structure. Pitched roofs are still proposed for all units?
I believe so.
Okay. So they're all 1 story, 1.5?
Is that correct?
Okay. Other comments, other thoughts? Okay. Anyone else you want to bring up on this one?
I don't believe so.
Okay,
Appreciate your time.
sounds good. Anything to say in closing before we close the public hearing?
No, appreciate the opportunity to present.
Thank you.
Thanks.
Anyone here to speak as a witness on this particular case? Any witnesses? Thank you so much. This time we'll close the public hearing and open for board discussion and deliberation.
I have no concerns?
I didn't have any concerns on this one. I thought the layout was great. I thought the stormwater retention was good. Mhm. Right, we called them, and they actually contacted staff almost a month ago and said they were going to withdraw that request. So, yeah. Yeah. Sidewalks provided, stormwater retention is provided. Looks good.
Mr. Chair, based upon the evidence presented to this board, including the following exhibits, that would be petitioner's application, the development plan, the supporting maps, the staff report, and the testimony at the hearing. I move that this board adopt the following findings of fact: that this matter was properly advertised, is within this board's jurisdiction, and is ripe for its consideration, that this application, together with the conditions proposed by staff and this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 78621, subparagraph 3.
There's been a motion on findings of fact. Is there a second?
I'll second it.
Hearing a motion and a second, all those in favor, please say aye.
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 Any opposed, nay? That motion passes. Thank you.
Mr. Chair, based on upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There is a motion to approve. Is there a second? Hearing a motion and a second, all those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you so much. This time we will consider an order on this particular case.
Try to make this a little bit bigger. All right. Chair and members of the board, I would recommend the following proposed order. The findings of fact, that this is a special use permit applied for pursuant to 78-641, 78-677, and 78-678 to establish a planned unit development for a 29-unit residential development at 220 Ledbetter Road. The property is located in R2 zoning district. That the applicant and all other parties withstanding were given an opportunity to participate, and that the board would make the following findings of fact, that the PUD, it will be under single ownership or management before final approval, that the density, number two, the density is consistent with the intent of the district, that the land uses are compatible and do not violate the intent of the zoning district, that the proposed use meets the minimum requirements for land development as follows. The minimum lot size and interior setbacks do preserve the spirit and intent of the zoning of this section and does comply with the zoning district. The proposed height standard does comply with the spirit of this section with respect to the total development plan. The board finds that the minimal distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles, that the development does provide reasonable visual and acoustical privacy for dwelling units, that the structure is located on the perimeter of the developments will be set back from property lines and right-of-ways abutting streets in accordance with the zoning ordinance. The board finds that the proposed parking does comply with the spirit and intent of this section. The board finds that the maintenance of open space, recreational areas, and communally owned facilities are in accordance with the Unit Ownership Act and other appropriate mechanisms as specified. The board finds that the building envelopes are in the submitted plans and depict the maximum expanse of the proposed footprint of the structure. That pursuant to 78-677G, the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use. That the proposed use will not be detrimental to the public welfare, injurious to public property or public improvements in the neighborhood. The proposed use will not have an adverse effect on surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress of the proposed use and proposed structures has been provided. The provisions for off-street parking where applicable comply with the zoning ordinance. Oops. Sorry about that. Provisions regarding utilities have been arranged for. Provisions for buffering, if deemed necessary, have been arranged for. Signs and exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with the district. Playgrounds, open spaces, yards, with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation are acceptable. The following conditions have been, are needed. The project must meet all the standards of the land development and subdivision. The prior approval to the preliminary plat of the subdivision must submit to an LOC from the City of Asheville Water Department. The project must be constructed in accordance with the site plan. Prior to commencement of land disturbance and construction activity, the applicant shall submit a site development plan permit for the entire project, including location of all buildings and accessory structures, a commercial lighting plan, buffing, landscaping, and parking, retaining walls, easements and right-of-ways, and approved E91 road names and other conditions as requested by the Board of Adjustment, which there are none, and a copy of any approved permits from the Army Corps of Engineers, DOT, or the NC Department of Environmental Quality where applicable. This master site plan permit shall not replace the requirement of pulling individual site plan permits for each building or structure within the development. The applicant must agree to these terms and conditions in writing prior to commencement of work. Based on the foregoing findings of fact, the board finds that the applicant's request for a special use permit meets the applicable requirements of the Buncombe County zoning ordinance, and therefore, based on the findings of fact and conclusions of law, the applicant is hereby granted a special use permit for the planned unit development.
There has been an order presented. Any questions, comments, modifications, motions?
If I may make a comment,
Please.
the condition concerning the water LOC, that was received, so that does not have to be conditioned.
Do you want me to delete that?
Yes, please. And then the first condition had to deal with the subdivision and land development ordinance. The word ordinance was left out.
Okay,
Thank
I
you.
thought so. And delete the LOC. Okay?
Thank you. Motion on the order?
Motion to accept the order?
There's a motion to adopt. Is there a second? Second. All those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you so much.
Thank you.
At this time, we'll go ahead and set up for ZPH 2024-00026, the Emma Road Townhome Special Use Permit. And we have Savannah Glantz to present that one. We're continuing this one from the February meeting. Yeah. Close to the mic. Yeah, we're having trouble. Yeah.
Is this okay? Oh, is that, okay. So hello again. I certify that this public hearing is properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code, and I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so accepted.
This is the review of ZPH 2024-00026, Emma Road Townhomes. Representing this application is Warren Sugg of Civil Design Concepts. The property is located at 815 Emma Road, and the total combined acreage is 12 acres. The development will be serviced by public water and sewer. The property is zoned R3, and the special use permit proposes 170-unit townhome development with various amenities, including a clubhouse, pool, pickleball courts, and playground. The application proposes deviations with lot size, interior setbacks, parking, maximum building height, and distances between buildings through this PUD process. If approved by the board, staff recommends the following conditions of approval. A preliminary and as-built subdivision application shall be required prior to submittal of draft final plat of this project. The draft final plat of this project must be reviewed and approved, and the plat must be recorded and lots platted with unique PIN numbers for each lot prior to the submittal of the master site plan permit. No drive to any unit may be more than 600 feet in either direction from any fire hydrant. The project must be constructed as depicted in the site plan, and applicant must agree in writing to these conditions prior to commencement of site work.
Any comments, questions for staff?
Have the DOT requirements been addressed in the plans yet?
I believe so, yes.
And perhaps now is a good time to kind of go over our plan for today. I don't know if you want to summarize what that is, or do you want me to? Or Griffin? Or Kurt? even better.
I believe that what we will do today is we will get the staff outlined, and then I think the parties have worked on standing, and we will try to get through all the standing applications today. And then is my understanding that the applicants and if the other people who are granted standing, then they would move to continue this to either the next meeting in April or a special meeting.
Okay,
That's kind of, I think, the plan for today.
thank you so much. Questions, comments?
Question, Savannah. I noted that under section G of the staff report, it concludes in bold print, staff has no objections to the request and offers the conditions below. So the opinion or the recommendation, or the staff's opinion is you'd have no objections to the overall request, or is this to specific requests?
So that specific condition, I will say, was requested to be removed in the staff report. In terms of the staff report in general, we see no issues with it meeting the ordinance standards.
Ordinance standards?
Yes.
Okay.
Well, obviously, excuse me, you'd be looking at the standards in the ordinance to see if it met said, but when they presented it to us, they met all the requirements in order to be seen here today.
Please don't take my question to challenge you. I appreciate.
Oh, no, not at all.
I appreciate
Yes.
the opinion being expressed.
Mhm.
See no other comments or questions? We'll thank Savannah.
Thank you.
Yeah. And at this time, we will turn to Griffin for an orderly rundown of the folks who have submitted standing applications in order.
Let's yeah.
Mr. Chairman, I think we can help.
Please.
Orchestrate things a little bit.
Mhm.
We did request a continuance. There was a pending one from John Knorr and his clients already. It was already on the table. We requested it. We had an engineer expert flying in with 3 layovers today. 3 times they had to get on and off a plane. It just wasn't going to be feasible for them to be here. As it turns out, my client also came down with the flu yesterday and is approaching hospital status. So these things have all come together to us supporting the continuance. But we have not been idle. We have attempted to resolve standing questions, so we didn't spend the day talking about standing. I'm willing, on behalf of my clients, to stipulate to the standing of Mr. Knorr's clients, which are generally they're abutting the project in question. They have reached out, apparently, there's been conversation with others who have submitted applications to weed down the herd, if you will. And I think we've been fairly successful, so I'm just going to turn it over to John with how successful we've been in terms of weeding down the standing applicants.
Thank you, Mr. Justice. Thank you.
Craig and I can't agree on things. So, just for the record purposes, the parties that we've agreed or Mr. Justice has stipulated for standing are Sarah McMullen. That application and affidavit we would just mark as OPP 1. Jacqueline Sullivan, which we would mark as OPP 2. And the group Poder Emma, PODEREMMA, which we would mark their application and affidavit as OPP 3. Those are the ones that Mr. Justice has stipulated to. I had a fourth application on behalf of Mahetsi LLC, MAHETSI. At this time, one of the reasons Mahetsi was applying was they were not able to have transcribed application materials provided at the last meeting. They reviewed those materials now that they have been translated, forgive me. And they are withdrawing their application for standing at this time and instead would just ask to be able to offer a witness statement at the appropriate time.
Okay.
And just for clarification, John, I think the property in question of Mahetsi involved two other folks, and it may have been tenants, who filled out applications. I've got Mr. Ramirez and Ms. Golden.
And Ms. Golden is here today, and it might work now that we've figured out who's stipulated to have Griffin run through the rest of the list and then have people withdraw or continue as they see fit. But these are the only four that I represented.
So based on the stipulation, I think that the next thing would be is for the board to grant standing to, or whether or not to grant standing to Mr. Noor, since it's been consented to, grant standing to his clients, and then we'll run down the list of people who haven't reached an agreement or whatnot.
Okay. We'll hear that application for standing from Mr. Noor, and then we'll have the board discussion on that.
For clarification, are the three that we are discussing now, are they all adjacent to the project site?
I know two are, Jacqueline Sullivan and
McMullen?
Sarah McMullen.
Correct. And the third, Poder Emma, is applying as an organization. They are applying through what's called associational standing. So under North Carolina law, they have standing so long as one or more of their members would have standing individually. And both Ms. McMullen and Ms. Sullivan are members of Poder Emma. So Poder Emma's standing is attached essentially to Ms. Sullivan and Ms. McMullen's application. Ms. McMullen and Ms. Sullivan are adjoining property owners. And as documented in the affidavit, if you need additional information, have laid out the basis for their special damages, which would be distinct from the community at large. I think Mr. Justice and I agreed that we were trying to streamline this, and I was not planning on calling either of them to offer testimony at this point. I can if the board has questions, but otherwise we would stick to the affidavit we'd previously submitted.
I think if you want to summarize for the board what the damages might be or what the alleged damages might be on behalf of those three, that might suffice.
Absolutely, happy to do that.
And while he's doing that, just to be clear for the record, that there's a difference between having a status as a party and otherwise proving something that may go to a substantive element of a claim. We're obviously not agreeing to the substantive side of things being said. This is merely
Just their
procedural.
participation.
And really to expedite things, we're willing to stipulate to the three applicants we've discussed.
Okay.
Mr. Justice, do you have any objection to the affidavits being entered in as exhibits?
No, and for procedural purposes only, for the standing, that they're part of the record already, and so, no.
Thank you.
I'll start with Ms. McMullen's property. As you'll see in the affidavit, hers is an adjoining property on what I would describe as the northern boundary of the proposed development site. She owns the property, lives there, resides there with her family. her concerns and the special damages that she specifically alleged relate to the construction of the development, light intrusion related to the roads that are dead-ending onto her property, as well as the deviation, as you noted from the staff report, the lot size, interior setback, parking, building separation, and building height limits do not meet the underlying zoning requirements. However, exceptions are being requested of the board through the PUD process. She thinks that those exceptions and the placement of the road and the retaining walls would result in a reduction of property value specifically to her property, has retained the services of an appraiser to offer expert opinion, which we are not offering today, but would at the substantive portion of the hearing offer. And that, generally speaking, is a condensed version of her basis for standing.
Okay.
I would say that that is not identical, but those concerns are similar concerns to those for Ms. Sullivan, but her property is positioned on the, what I would call southeastern property line on the other side. I'm happy to go into those specifics, but for time purposes, can leave it there as well.
I have no additional questions.
Okay. I think we're ready, if y'all are ready, on a motion to approve, to grant standing.
So who's the first person we're going to grant standing to? Or
Taking them in order, I mentioned Sarah McMullen first. We would then go on to Jacqueline Sullivan and then Poder Emerald last.
so let's deal each one with a separate motion.
Okay.
Chair, I put forth the motion to accept McMullen as a witness or a party in standing.
There is a motion. Is there a second? Hearing a motion and a second. All those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you.
The next would be Jacqueline Sullivan. That's OPP 2. As you note, her property is on the southeast corner of the development site. Her concerns relate similarly to retaining wall placement. There is not a road issue with her property, but also the deviation from the underlying zoning requirements and the impact that will have on the property of, on the value of her property.
Okay. Motion on Sullivan.
Mr. Chair, I put forth the motion for the party McMullen to be accepted as a party with standing.
Sullivan as well, right?
Excuse me, Sullivan, yes.
Is there a second on that? Second. Motion and a second. All those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you.
The last would be Poder Emma. Poder Emma is an association that has been working in the Emma community for a number of years at this point. It was not formed in response to the development project, and both Ms. Sullivan and Ms. McMullen are members of Poder Emma. As an association, their standing would be based on the standing of their individual members, which you just approved. If there are any questions, I can go into that, but would leave that there.
We have their application here. Motion on Poder Emma.
Yeah, I move to accept the application of the, I move to accept the request from the applicant to be a party of standing.
There's a motion. Is there a second?
Second.
Hearing a motion and a second. All those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you.
And as I indicated before, Mahetsi LLC has withdrawn its application for standing and would only seek to offer a witness statement at the appropriate time, and that's the last of the
Thank you for
parties
that.
that I represent.
Perfect. And at this time, we'll move to others who have submitted previously for standing. I think Gardner's our first applicant.
Yes, Isabella Gardner.
Is Ms. Gardner here?
Thank you.
Elsa Klein.
Thank you.
The next one is Cecilia Span. We did receive email correspondence from Cecilia Span indicating an intent to withdraw the request for standing.
Thank you.
Paul Butler.
Butler. Thank you.
Sarah Warren.
Thank you.
And the next, McMullen and Sullivan have been addressed. The next four individuals, we were informed by Mr. Noor that they are intending to withdraw their standing applications, those being Andrea Golden, Alan Luis Ramirez, Ingrid Johnson, and Rebecca Brown. Is that correct? Okay. Okay.
Okay.
Okay.
Mhm.
In that case, Andrea Golden? Okay, you are withdrawing. Okay. And we did receive email correspondence individually from Alan Luis Ramirez, Ingrid Johnson, and Rebecca Brown
Okay, perfect.
that they are withdrawing.
Okay.
Next is Carrie Fernandez.
Ms. Fernandez? Okay, thank you.
Forrest Smock. Okay.
Do you wish to proceed with your standing application? Yes, I would. Okay.
Okay.
Okay. Please raise your right hand and state your name.
My name is Forrest Smock.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir.
Thank you.
Appreciate being here. If you'll go through briefly for the board, any reasons why you might assert standing in this matter and qualifications for standing status?
Sure. If it's okay, I will proceed with reading my prepared statement.
Okay.
Good afternoon, members of the board. My name is Forrest Smock. I am a nationally registered emergency medical technician, and I've practiced under that medical license for the last 10 years. I'm also a graduate student at Western Carolina University. I appreciate the opportunity to speak before you today regarding my application for standing. I live at 237 Brickyard Road, which is within 600 feet of the proposed development. While any large-scale construction brings general community concerns, my household faces unique and specific risks that go beyond those of the public at large. My fiance, who shares our home, lives with a chronic illness that makes her highly sensitive to air quality and noise. Even small environmental changes can quickly trigger debilitating flares of her condition, impacting her ability to work, which she does from home, rest, which again, she does at home, and maintain her health. Again, an activity that is central to our shared home space. The scale and extended timeline of this development raises significant concerns for us. The prolonged construction process, bringing dust, emissions, and persistent noise, directly threatens her well-being. Exposure to airborne particulates and disruptions to the quiet she relies on for daily recovery could result in serious health consequences, forcing us to consider difficult choices about where we live, the need to relocate in order to maintain her health, and how she sustains her work. This is not a hypothetical or minor inconvenience. It is a matter of her ability to function in her own home. These damages are not just about discomfort or preference, but about real personal and medically significant harm that we as a household would uniquely endure. For these reasons, I respectfully ask the board to recognize my standing in this matter.
Thank you for that. Let's hear from the applicant and Mr. Noor as well on this, and then we'll have board questions.
Of course.
My intention today, unlike my general pass, is to not to object, so we're not going to oppose this particular applicant. With the understanding, of course, to the previous caveat that I said, that about the substantive claims that are made, that we'll address them during the hearing process. We don't agree with it.
Okay. Thank you. Thank you. Anything from the board? And we assume during the hearing, when we get there, whether it's this month or next month, probably next month, that you'll have evidence on these matters as well, that these claims, yeah?
Yes, I will now prepare in that way. When I submitted this application, I had not received the additional materials that were provided in the interceding month before, when we were here last month. And this, or with the additional information that you all have provided.
Thank you.
Yeah.
Thank you. Comments, questions, thoughts from the board, or motion?
Motion to approve standing.
Second. Motion, hearing a motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you, sir. You're granted standing in this matter.
Thank you very much.
Feel free, we have two tables really set up right here. You can feel free to seat yourself on the first row if you'd like to, just to be called on, or if you want to share seating, that's fine.
I understand. Thank you very much.
Final application for standing that we received was from Jordan Witten, and we did receive email correspondence from Jordan Witten indicating an intent to withdraw that application.
Perfect, okay. Is there anyone in the audience here, in the public here, that would like to assert standing that has not been called on yet? Anybody here to assert standing in this matter? And going 3 times, thank you. There is a additional motion attached here in our documentation to continue. So let's,
However, before we move to the motion to continue, I would ask that the board make a motion to close standing applications so that when we come in April, new people cannot apply for standing.
excellent idea. Let's do that.
If I could just be heard on
Yes.
that. I do not have any other clients that would fit into this category, but I do want to note for the board, I mean, someone can apply for standing even after you made your decision. Before the Superior Court. So the idea that someone who might appear at April for the first time, having learned about it for the first time, wouldn't have the ability to apply for standing, I just think it would be the incorrect way to approach that for someone who's coming to the board and seeking to be heard by the board, when if they allowed you to go through your entire process and then applied before the Superior Court, would have an opportunity to intervene in the case. So,
We've had numerous, I mean, I guess I would just say that the county has posted public notice. This hearing's been on the agenda for multiple times and things like that. Obviously, that's your discretion as you want to keep standing open, but then you're going to get the standard flare of, oh, well, I'm going to need a continuance to get my experts and things like that. So that's my more concern of having any more delays in this process.
Thank you. Mr. Justice?
I guess John brought this up because we have to have something to disagree with today.
Well done, John.
This is a standard practice that the board has followed with this opening the hearing to allow people to seek standing. And in seeking party status during this journey is no minor thing, meaning it puts a burden on a party to send information out in advance of the hearing to the other parties. You have that rule that's in place. Just being able to organize who has the right to call witnesses. All these things are important for organizational and scheduling purposes. At the end of the day, John is right that if somebody later wants to petition to the court for standing, at that time, because of legislative changes that have occurred that I was part of, that individual at that time can submit affidavits and produce evidence in front of the court as to standing later, potentially. So they're not necessarily foreclosed. But for purposes of trying to understand these proceedings and get through an orderly fashion, it has been your practice to open it up, have a standing discussion, and then close it. And that's what I would ask you to do, is to follow your normal process.
Open up for board thoughts and discussion. Just my initial thought is thinking about staff's comments here that you have to kind of look at the meeting as a whole, between whether it occurs on one day or whether it occurs 3 meetings in a row, continued 2 times. So we have to go through a process and an order to the meeting. That's the way I would look at it, that we have a particular time for standing to be asserted. We're at that time now, so.
I have a question. What if property exchange changes hands? If someone should move into the neighborhood, would we be denying them standing if we close it?
We would be, and that's a question for the board. It's a very valid point. Yeah. It's a tough one, yeah.
And to Kurt's question, Kurt, the board's not obligated to grant a request for continuance for someone who comes forth and is granted standing at some point in the future. We're not obligated, are we?
No, you have discretion as to whether to grant a continuance or not, much like I believe you have discretion to consider standing applications at a specific time or not. Once again, I don't think there's a case on point, so I can't specifically say whether or not, someone who comes in here and requests standing at a later date. However, I do know from experience that when we have multiple hearing dates, that possibly exists, and that does at times gum up the works. So I leave it in your discretion, but I do think that we should either, if you're going to allow standing applications in the future, that's fine for this case, but if not, I think that now would be the appropriate time to close it off.
Yeah, I have a question for Kurt. Would it be acceptable if the board wanted to do this, to say, we'll leave the request for standing open for a future meeting with the caveat that we will not allow any, the word I just lost the word.
Are you speaking of continuance?
Yes, thank you. We would not allow continuances?
That would be within your discretion, but I don't think you'd want to rule on a continuance until you've actually heard the request, because, what if somebody's sick or, we've had those things, so that would be, I don't think, I would not recommend ruling on something prior to that, because once again, standing is your ability to participate in the hearing as a party. That does not prevent you from coming and speaking as a witness. That also does not prevent you from appealing the decision should you be unhappy about it. This is the only question about you being able to participate in the hearing as a party at this time.
Question for staff, when was this case originally publicized?
It was publicized at least 10 days prior to the board's special meetings in December, which were on December 11th, 2024.
And does our process include republicizing if it gets continued and moved to March?
So if a matter is continued to a date certain, we're not legally required to re-advertise, but we have generally done so as a courtesy and to, increase public awareness.
And has that been the case with this case?
That has been the case with this case.
All right, thank you.
I'm ready to. Any more discussion on this? I was leaning towards closing, and now I'm leaning the other way. Yeah. So keeping it open. But it's up to y'all.
I was going to lean the other way.
Oh, were you leaning? Go ahead, lean the other way.
It doesn't lean the other way. It's been publicly communicated numerous times.
Yeah.
Those that have an interest in the case should have seen it through all of the public notifications.
If property changes hands, they don't know.
That's
And
the-
so are we cutting them off? I
That's the
mean,
point,
I think
somebody-
that seems wrong.
That would be the case in every time.
When anything is continued.
Okay, we'll take a motion either way and see how it goes.
Chair, put forth a motion to close the applications for standing at this time.
Hear a motion to close, and we'll hear a second.
I'll second that.
Okay. Any discussion?
I just object to it because I always object to anybody losing their rights, and I think this would indicate that they would lose their right. If property should change hands, they should have the same right as people that are property owners right now.
Okay.
Recognize and respect that. My just counter is due process. It can just, we could prolong and continue this without giving the applicant the opportunity to get a fair and speedy decision.
Right. That's a tough one, but if we're ready, we'll call for the vote. We'll do a raise of hands on this one. So yes, as you do want to close standing applicants at this point. All those in favor of the motion? 4 in favor. Any opposed to the motion? That motion carries. Thank you very much. We are closed for standing applicants. Thank you. At this time, we will hear a motion, I believe.
I think
Is it a
it's-
joint motion?
Can we call it a joint motion? I think we have both moved in different ways. Our motion to continue was to ask to your April meeting. I think Mr. Justice's motion was due to conflicts with his expert and illness, that he would like it moved. I think we have both agreed that if the board was open to a special sitting of this on April 2nd, we would be open to that. And I think your regular meeting in April would be April 9th.
Yes, however you want to play it out in terms of resetting this, as long as it's.
Okay. Can we hear about the current queue that staff has or staff's aware of? I know it can change between now and next month quite a bit, but anything we're sure is queued up for next month beyond this?
There are at least 3 to 4 matters that have been pending hearing for a considerable time, at least since January. And we've already had to push them a couple of times. So the board will have to consider that in how it wants to proceed with this continuance request. That's what I'll say on that.
Yeah. That's a tough call as well, but we have had this case before us a couple of times, need to get through it. And certainly probably should do that within our allotted time.
Is it appropriate to ask? Yep.
I consent to an April 2nd meeting special in alignment with those.
Thank you.
Number of witnesses, expected time for presentation.
We can hear about that, but it can always change, so.
So I've done a number of these with y'all, and so generally, if no one was asking any questions, I could generally get through in about an hour and a half. The problem is that John likes to hang out probably with my witnesses and spend some time with them, and that's what I can never predict. I always get in trouble when I go to court and I say, Judge, I think it's only going to take 2 days, and I'm talking about my time, and the other side takes 15 days, and then I get blamed for having guests to begin with. So I think
We will not take 15 days.
I'm glad we can agree on that. So to your question, an hour and a half to get through our witnesses, and then it's really up to them.
What's the board's feeling here?
I
Oh, sorry,
think that
Craig.
this is going to probably end up taking at least a full 4, I would at least
think
at a
so.
minimum block for a 4-hour session. And so I do believe that this will take at least 4 hours to complete, based on my experience in hearing these cases. And that's assuming that everything goes well. If things get a little weird, we may have to continue it to another date certain. So do keep that in mind.
I'm generally in favor of keeping our regular schedule and all the cases in the queue in that way. Something to be said for putting this on a special agenda for a special meeting, because then we would have a time-limited period to try to pressure to get through.
The
Yes.
only other suggestion staff could make is possibly holding a morning session on the 9th specifically for this case. That would be the only possible other, or you could set it, you can set a special meeting whenever you want. Apparently, the parties have agreed to April 2nd, but, you need to also work on your schedule if that's the route you decide to go.
We've done, 2 double sessions this year already, and it's fun, but, it's difficult for the board to all get all members on one day.
No,
So it
I
is
agree.
difficult for staff.
I respect your time, and your
Yeah.
volunteers, I completely understand that, but,
Yeah, question for staff. What kind of backlog does that create if we just meet on a regular time?
well, it depends where you put this case. If you put this case first on the agenda on April 9th, probably any cases behind it are going to get continued until May. So if you can put this, but then if this goes behind the other 3 cases, there's no guarantee that we would get to this case on the 9th. That's kind of the catch-22, and this has been continued a couple times. So that's kind of what we're wrestling with.
I struggle with this one in terms of we're creating a pattern. I think that's what you're alluding to, Andy, is that we've already through this year started to expand and go morning and afternoon sessions and maybe special dates. And so I'm worrisome on that aspect of this issue.
I share those concerns, and I think that the real concern is having it slated for next month and not getting through the case next month, having to continue Emma to May. And
And also not hearing any of the cases
also
that
not
we
hearing-
had planned for April too.
So
Yes.
that concern is not just that, it's pushing cases that could have been heard in, March, maybe here, to June, so.
Yeah, personally, let me just observe, I am all in favor of having special meetings so as not to back up applications that we have. I realize that we have a group of alternates, and I will just observe that I can't make the second, personally. It'd be fine with me to have a morning section on the 9th.
Mr. Chairman, can I just ask one
Please.
question of Griffin? In terms of how much time needed to get out
did,
notice, I'm not, in the default would always be, we end up on April 9th. That is a default, because that's the next regularly scheduled meeting. The question is whether the group is willing to do a specially called meeting, and it may be that everybody doesn't have their calendars and you don't know for sure. I'm just wondering, do we have time to figure that out this week so that y'all can work with the board and just figure it out and let us know, and then we'll work with you on setting it. We've already indicated April 2nd is available to us, but y'all may have a different date that you may want to consider. I'm just wondering, how much time do we have for purposes of notice?
So I don't see why we couldn't figure that out outside of this meeting. What I will say is that notices for a hearing of this case would need to be completed no earlier than 25 days and no later than 10 days prior to that meeting. So, I mean, that would, let me take a look at the calendar and see where that would put us.
April 2nd.
April 2nd would be fine because we would then,
And my only concern would be is, let's say we continue to April 2nd, we can't get a quorum.
right.
Then we would have to figure out where does it go? So, but I think what you're asking is try to figure that out ahead of time. But we need to deal with your motion to continue today. And
Yeah.
normally we would continue it to a date certain.
Well, I'm saying, rather than having to make final decisions on an alternative special date, if one had time to get with the board and discuss that offline, and you all say, a quorum can be present on such and such day and such day, then I would get with John, and if it's some other day besides April 2nd, we would just communicate that, and we could work it out so that we're not sitting here stressed about, are we locked into April 2nd or April 9th? Because I understand that, one of the board members said, I can't be there on April 2nd. So just trying to be open and accommodating and how much time we have to figure it out.
No, I think we can try to get that figured out. That sounds like, if that's good with you, John.
On behalf of my clients, we have no issue with the board trying to identify another date other than April 9th, which will be the default at this point. We would only ask to be consulted on that because we did check the 2nd and the 9th with our experts to make sure that they would be available, and would just want to be able to do the same thing with whatever other date the board might come up with.
So we've heard the discussion so far, I think, and the board, I'm going to float a notion here, that the board consider April 2nd for a special meeting for this case from 9 to 1.
I would recommend continue it until April 9th. And then if we are able to get the special meeting together, we were able to get a quorum, then we can advertise the special meeting, and the parties then consent to be present at April,
But don't we-
on April 2nd.
Well, technically,
Well, no, you're going to continue it until the 9th. So the 9th's going to be the formal thing. But let's say we can get a quorum and the parties agree, then we go April 2nd. We advertise the special meeting, and then they hold the hearing on the 2nd.
We could do it that way, but Griffin, isn't it true for special meetings as well, that you just email out and we figure out who can make a certain meeting?
Right, we're gonna have to figure that out.
Yeah.
I wasn't aware that a special meeting could be called for a hearing of a case prior to a date to which it was already continued.
We would then have to publish notice.
well, I think you could continue this to April 2nd. If there wasn't a quorum, you're allowed to then continue it to a date certain, which could be.
If we couldn't make April
9th.
2nd work after we heard from the board members, we would do it the 23rd or something, whatever date did work.
That's
So-
fine, too.
I'd rather do it that way and separate it from the regular agenda to have our other folks who are waiting in line appear in April at the regular meeting,
No objection from my clients on setting it for the 2nd and then adjusting as needed.
if needed, yeah.
Right, so presumably, we would move forward now with calling the special meeting for April 2nd. And if we're unable to get a quorum to attend, that meeting would then be canceled and the case would be continued again?
Right.
Okay.
We look for another date later on in April for that, the standalone. Is that agreeable to the parties?
Yes.
Okay.
Yes, Mr. Chair.
What does the board think about this idea?
Yeah, it's fine by me.
For what Griffin said.
Motion for what Griffin is typing right now. Yeah. Okay, so we'll make that motion. Is there a second?
Second.
All right, motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you very much. We're continued to April 2nd, 9 to 1. Are there any other matters from staff today?
Not that I am aware of, other than I will be sending out an email to confirm the attendance for April 2nd, likely later today.
Perfect. Any other matters from the board? If not, we'll hear a motion from the board.
Motion to adjourn?
Motion to adjourn. Is there a second? All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? We're adjourned. Thank you.